Hello, I'm Jennifer. Welcome to another episode of Case Brief, brought to you by the Missouri Sheriff's Association. Before we get started, I want to remind everyone that this information is for training purposes only and in no way is to be considered legal advice. Today, we focus on an Eighth Circuit Court case related to the Religious Land Use and Institutionalized Persons Act and restricting an inmate from having a Bible while in administrative segregation. Our goal is to provide a clear understanding of how such cases unfold. Remember, this content is educational and not legal advice. So, let's dive into the details. Dewey Barnett sued Jefferson County, Missouri and jail administrator Brenda Short, alleging that while he was in administrative segregation at the Jefferson County Jail, he was denied religion, the Holy Bible. He further alleged that his lack of a Bible caused him anxiety, stress, and depression, and he said that he felt guilt and shame because the deprivation led him to sin and be a sinner. Barnett attached 2 exhibits to his complaint. One was a grievance he submitted to the jail asserting that he had been placed in administrative segregation 3 days earlier and was told he could have a mattress and blanket, but no property, no hygiene, and no Bible. Barnett wrote, "It is in the Constitution of the United States." Someone from the jail responded by writing that Barnett could have nothing more and that his behavior has taken away all privileges. The response continued, "Feel free to quote the Constitution all you want to, I don't mind at all. You will not receive anything more." The second exhibit was a handwritten letter that Barnett wrote to a lieutenant in the Sheriff Department's Internal Affairs Division regarding grievances he had with the jail, and he expressed fear that he would not be released from administrative segregation as scheduled about a week later. The district court reviewed the complaint before service and dismissed the action. It first held that Barnett's Arluipa claim could not succeed because Arluipa does not permit plaintiffs to recover money damages, and his request for injunctive relief was moot, since Barnett had been transferred to another facility. As for the claim under Section 1983 that Short had violated Barnett's constitutional right to the free exercise of religion, the district court held that Barnett didn't adequately plead Short's personal involvement in the decision to deprive him of his Bible, and that the decision didn't substantially burden his free exercise. The district court also dismissed Barnett's 1983 claim against the county, explaining that he had failed to allege that it had a policy of denying Bibles to inmates in administrative segregation. Barnett appealed the dismissal of both his Arluipa and 1983 claims. The Eighth Circuit Court found that appropriate relief under Arluipa includes damages, that the district court erred in dismissing Barnett's Arluipa claim against the county, and that the district court properly dismissed Barnett's Arluipa claim against Short in her individual capacity. Next, the court looked at whether the district court properly dismissed Barnett's 1983 free exercise claim against Short in her individual capacity as well. Barnett maintains that the court strayed off track when it read his complaint as not implicating Short in the decision to deny him a Bible. For this claim to succeed against Short, Barnett must allege specific facts showing that Short was personally involved in or directly responsible for the deprivation of his constitutional rights. The Eighth Circuit Court found that the district court correctly observed that the officer who responded to Barnett's request for a Bible didn't sign a name next to the written denial of the request, and that Barnett did not refer to Short in the portion of his complaint that provided an approximately 30-word summary of what had happened to him. In his letter to Internal Affairs, Barnett brought up the numerous grievances I filed with Brenda Short. He also emphasized that everything at the jail went through Short, as she is judge, jury, and executioner. Taking all this and Barnett's other submission together, the Eighth Circuit Court found that Barnett sufficiently alleged Short's personal involvement. The Eighth Circuit Court also disagreed with the district court's alternative holding that even if Short was personally involved, her decision to deny Barnett's request didn't substantially burden his religious exercise. To succeed on this claim, Barnett must allege that the jail placed a substantial burden on his ability to practice his religion, which occurs when a decision meaningfully curtails a person's ability to express adherence to his faith or denies him reasonable opportunities to engage in those activities that are fundamental to a person's religion. According to the Eighth Circuit Court, given that Short allegedly deprived Barnett of a Bible for a whole month rather than a single day, the court felt Barnett has alleged a substantial, not a de minimis, burden on his religious exercise. In sum, the district court properly dismissed Barnett's RLUIPA claim against Short and his 1983 claim against the county, but the Eighth Circuit Court reversed the district court's decision to dismiss the RLUIPA claim against the county and the 1983 claim against Short, and remanded the case for further proceedings in the district court. Before we conclude, I want to say that we do not know how this case is going to turn out on remand, but I do want to review a few critical points to ensure we understand the legal framework and best practices. While RLUIPA imposes strict scrutiny, jails must also consider the Turner v. Safley 1987 test, which determines whether a jail regulation that limits constitutional rights is reasonable. Turner establishes 4 factors that guide whether a jail's restriction is justified. Those factors are: 1. Legitimate and rational connection. Is there a valid rational connection between the restriction and a legitimate penological interest, as in safety, security, or order in the facility? 2. Alternative means of exercising the right. Does the inmate still have other means to practice their religion, for example, oral prayer, religious discussions, PR access to a chaplain? 3. Impact on facility operations. Would allowing the material pose a threat to staff, other inmates, or the facility's function? And 4. Existence of ready alternatives. Is there an alternative policy that would accommodate religious needs without compromising security? If an inmate in administrative segregation for bad behavior requests a Bible, the jail must ensure its denial meets Turner's standards. A blanket ban on religious texts in segregation likely violates RLUIPA, because it places a substantial burden on religious exercise without a compelling interest. However, if the denial is based on legitimate security concerns, for example, the inmate has used books to conceal contraband or create security threats, it may be defensible under Turner if alternative religious accommodations are provided. Thank you for joining us in this episode of Case Brief. We hope this analysis provided valuable insights into religious right of inmates and restricting religious material. Stay tuned for more episodes brought to you by the Missouri Sheriff's Association. If you enjoyed this content, please like and subscribe. We look forward to bringing you more informative episodes in the future.